All right. Hello, everyone, and welcome to another episode, another rendition, another evening of reading Remedies with Aaron. Today, we're going to be covering the scope of liability. The first case we are looking at here is Pruitt v. Allied Chemical Corp. It's a Virginia federal court case from 1981. Mayor Hage, the district judge, is the one authoring the opinion. Plaintiffs bring the instant action against Allied Chemical Corporation for Allied's alleged pollution of the James River and the Chesapeake Bay with a chemical agent, dun, 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 commonly known as Kepone. Kepone was an insecticide that has since been banned, partly as a result of the events at issue in this case. Fishing was closed for 13 years on 100 miles of the James River. Plaintiffs allegedly engaged in a variety of different businesses and professions related to the harvesting and sale of marine life from Chesapeake Bay. All claim to have suffered economic harm from defendants' alleged discharges of Kepone in the James River and thence into the bay. Defendant moves to dismiss 9 counts of the complaint as they apply to all plaintiffs other than those directly engaged in the harvesting of the bay's marine life. That is, defendant would dismiss the 9 counts as to all plaintiffs except those classified in paragraph 6A of the complaint, generally fishermen, shell fishermen, and leasers of oyster beds. All plaintiffs subject to the defendant's motion claim lost profits resulting from their inability to sell seafood allegedly contaminated by defendant's discharges, and from a drop in price resulting from a decline in demand for seafood coming from areas affected by Kepone. These plaintiffs can generally be described as parties suffering only indirect harm to their property or businesses as a result of the Kepone pollution. They or their possessions have not been caused direct physical damage by defendant. Instead, plaintiffs allege that the stream of profits they previously received from the businesses or employment has been interrupted, and they seek compensation for the loss of the prospective profits they have been denied. Counts 1, 2, and 5 allege that negligence of some degree by defendant entitles the plaintiffs to recover. Count 3 alleges that the effluents released by the defendant were, quote, defective and unreasonably dangerous, and that the defendant should be strictly liable for any harm caused by its discharges. All of these counts arise from the court's diversity jurisdiction and rely on theories of state tort law. The Virginia Supreme Court has never directly considered the question of recovery for loss of prospective economic benefits. It is commonly stated that the general rule for both admiralty and at common law has been that a plaintiff cannot recover for indirect economic harm. The logical basis for this rule is obscure. Although courts have frequently stated that economic losses are not foreseeable or too remote, these explanations alone are rarely apposite. As one well-respected commentator has noted, the loss to plaintiff in each case would be readily recoverable if the test of duty or remoteness usually associated with the law of negligence were applied. That's from James Fleming Jr., Limitations of Liability for Economic Loss Caused by Negligence, a Pragmatic Appraisal. Vanderbilt Law Review, 1972. The court frankly acknowledges the fact that there exists a substantial number of cases that may be construed to establish a general rule favorable to the defendants, as noted by the Ninth Circuit Court in Union Oil Company versus OPEN, 501 Second Federal Supplement, 558 Ninth Circuit Court, 1974. The general rule has found application in a wide variety of contexts. Quote, the negligent destruction of a bridge connected to the mainland with an island, which caused a loss of business to the plaintiff who was a merchant on the island, has been held not to be actionable. A plaintiff engaged in commercial printing has been held unable to recover against a negligent contractor who, while engaging in excavation pursuant to a contract with a third party, cut the power line upon which a plaintiff's process depended. A defendant who negligently injures a third person entitled to life care medical service by a plaintiff is liable to the third person but not to the plaintiff. If operators of a dry dock are not liable in the admiralty to the characters of a ship, charterers of a ship, rather, placed by its owners in the dry dock for negligent injury or the ship's propeller, while the injury was derived from the character of the use of the ship. Nevertheless, there also exist cases that conflict with this broadly recognized general rule. At least 2 of the minority cases deal with precisely the case present here. What the hell? For some reason, Daryl Brooks' trial is playing in the background. That's weird. Well, whatever. All right. Nevertheless, there also exist cases that conflict with this broadly recognized general rule. At least two of the minority cases deal with precisely the case present here: the loss of business opportunities due to pollution of streams adjoining a plaintiff's property. Moreover, even defendant concedes that a third case, Union Oil, that provided compensation for fishermen for losses caused by pollution from oil spills, is is correctly decided, rather. Although the defendant would distinguish Union Oil as limited solely to those who labor on the water, but not at its water's edge, the rationale for creation of this particular distinction is unclear. Given the conflicting case law from other jurisdictions, together with the fact there exists no Virginia law on indirect economic damages, the court has considered more theoretical sources in order to find the principal basis for its decision. There now exists a considerable amount of literature on the economic rationale for tort law. In general, scholars in the field rely on Judge Learned Hand's classic statement of negligence, footnote 11, we'll get there, to argue that a principal purpose of tort law is to maximize social utility. Where the cost of accidents exceeds the cost of preventing them, the law will impose liability. So, from Learned Hand's opinion, see United States versus Carroll Towing Company, a Second Circuit decision in 1947, in which Judge Hand stated that a person's duty to prevent injuries from accident, quote, is a function of three variables. 1, the probability that the accident will occur. 2, the gravity of the resulting injury if it does occur. And 3, the burden of the adequate precautions. The difficulty in the present case is how to measure the cost of Capone pollution. In the instant action, these costs were borne most directly by the wildlife of the Chesapeake Bay. The fact that no one individual claims property rights to the bay's wildlife could arguably preclude liability. The court doubts, however, whether such a result will be just. Nor would a denial of liability serve social utility. Many citizens, both directly and indirectly, derive benefit from the bay and its marine life. Destruction of the bay's wildlife should not be a costless activity. In fact, even the defendant in the present action admits that commercial fishermen are entitled to compensation for any lost profits they may prove to have been caused by defendant's negligence. The entitlement given to these fishermen presumably arises from what might be called a constructive property interest in the bay's harvestable species. These professional watermen are entitled to recover despite the lack of any direct physical damage to their own property. Presumably, sport fishermen share the same entitlement to legal redress for damage to the bay's ecology. The court perceives no valid distinction between recognition of commercial damages suffered by those who fish for profit and personal harm suffered by those who fish for sport. The claims now considered by the court, however, are not those of direct users of the bay, commercial or personal. Instead, the defendant has challenged the right of those who buy and sell to direct users of the bay to maintain the suit. None of the plaintiffs here, including commercial fishermen, has suffered any direct damage to his private property. All have allegedly suffered economic loss as a result of plaintiffs' harm to the bay's ecology, or defendants' harm to the bay's ecology. Apart from these similarities, the different categories of plaintiffs depend on the bay in varying degrees of immediacy. The commercial fishermen were fit within a category established by Union Oil. They, quote, lawfully and directly make use of the resources of the sea. The use of that marine and charter boat owners make of the water, though hardly less legal, is slightly less direct. And indeed, businesses in similar situations have been held entitled to recover in other courts. Still less direct, but far from non-existent, is a link between the bay and the seafood dealers, restaurateurs, and tackle shops that seek relief, as do all the employees of these establishments. One meaningful distinction to be made among the various categories of plaintiffs here arises from a desire to avoid double counting in calculating damages. Any seafood harvested by the commercial fishermen here would have been bought and sold several times before finally being purchased for consumption. Considerations both of equity and social utility suggest that just as defendant should not be able to escape liability from a destruction of publicly owned marine life entirely, it should not be caused to pay repeatedly for the same damage. The court notes, however, that allowance for recovery of plaintiffs' lost profits here would not in all cases result in double counting of damages. Seafood wholesalers, retailers, processors, distributors, and restaurateurs allegedly lost profits when deprived of supplies of seafood. Those profits represent a return on the investment of each of the plaintiffs in material and labor in their businesses, and thus the independent loss to each would not amount to double counting. Conversely, defendants could not be expected to pay, as a maximum, more than the replacement value of the plaintiff's actual investment, even in the stream of profits lost, where extrapolated into the future would yield greater damages. Tracing the stream of profits flowing from the bay's seafood, however, involves the court in other complexities. The employees of the affected businesses have no physical investment in their employers' businesses, yet plaintiffs' allegations are proven these employees undoubtedly lost wages and face a less favorable job market than they would have but for defendants' acts, and they have thus been harmed by defendant. What is more, the number of parties with a potential cause of action against defendant is hardly exhausted in plaintiff's complaint. In theory, parties who bought and sold to and from the plaintiffs named here also suffered losses in business, as did their employees. In short, the set of potential plaintiffs seems to be almost infinite. Perhaps because of the large set of potential plaintiffs, even the commentators most critical of the general rule on indirect damages have acknowledged that some limitation to liability, even when damages are foreseeable, is advisable. Rather than allowing plaintiffs to risk a failure of proof as damages become increasingly remote and diffuse, courts have in many times raised an absolute bar to recovery. The court thus finds itself with a perceived need to limit liability without any articulable reason for excluding any particular set of plaintiffs. Other courts have had to make similar decisions. Footnote 22. Judge Kaufman's opinion in Petition of Kinsman Transit Company, to Second Circuit Court 1968, where the court noted that in the final analysis, the circumlocution, whether posed in terms of the foreseeability, duty, proximate cause, remoteness, etc., seems unavoidable, and then turned to Judge Andrews' well-known statement in Tagstaff versus Long Island Railroad, New York Supreme Court case from 1928, where he said, "It's all a question of expediency, a fair judgment, always keeping in mind the fact that we endeavor to make a rule in each case that will be practical and in keeping with the general understanding of mankind," whatever that means. The court concludes that plaintiffs who purchased and marketed seafood from the commercial fishermen suffered damages that are not legally cognizable because they're not sufficiently direct. This does not mean the court finds the defendant's alleged acts are not the cause of plaintiff's losses, or that plaintiff's losses were in any sense unforeseeable. In fact, in part because the damages alleged by the plaintiffs here were so foreseeable, the court holds that owners of fishing boats, tackle bait shops, and marinas have suffered legally cognizable damages. The court does so for several reasons. The Fourth Circuit Court has held in admiralty the defendant should, quote, pay once but no more for damages inflicted. Venmore Transportation Company versus M.V. Struma, Second Federal Reporter 707, 710, Fourth Circuit decision from 1978, where commercial fishing interests are protected by allowing the fishermen themselves to recover, it is unlikely that sport fishing interests would be equally protected, because the damages each sportsman suffered are likely to be both small and difficult to establish. It is unlikely that a significant proportion of such fishermen will seek legal redress. Only if some set of surrogate plaintiffs is entitled to press its own claims, which flow from the damage to the bay's sport fishing industry, will the proper balance of social forces be preserved. And there's a footnote to suffered damages that are both likely to be small. The net loss to any sportsman would have to take into account any enjoyment received from natural areas visited as a substitute to the Chesapeake Bay. So people who go out to fish and enjoy the ocean and enjoy seeing the waves and catching the fishes, but can't go there anymore because it's polluted and they can't catch the fish or be on the water, they'll probably go somewhere else to enjoy sport fishing and enjoy, sailing the ocean blue. And so they will most likely get some enjoyment from that other waterway, the other ocean voyage, and the other fish elsewhere in the world they might catch. And so that has to be weighed as another option for them when calculating their damages. Yes, I suppose like Florida. However, they would have to incur cost of getting their boats from Virginia to Florida and finding a harbor for them or a marina to store them at in Florida. So those could ostensibly be damages they could sue for, because in order to take enjoyment from the new waterway and sport fishing environment, they would have to move their boat, register it in Florida, find a harbor or marina or a port or whatever to store it in. And those costs would be directly related to the fact that the Chesapeake Bay is all polluted with Capone or whatever it is. So, yuppers. Let's see here. We have now. We have some notes after the case, but I'm trying to see if there's a. Let's check here. Okay, I thought so. Yeah, there's another case. Sunnyland Farms Incorporated versus Central New Mexico Electric Cooperative Incorporated. It's a New Mexico Supreme Court case from 2013. Let me get a pen out, actually. All righty. Chavez, the justice writing the opinion. Sunnyland Farms purchased its electricity from the defendant, which the court calls CNMEC, CNMEC. On September 8th, 2003, CNMEC shut off electrical service to Sunnyland. Prior to disconnecting electricity for non-payment, CNMEC ordinarily gives its customers notice that they have 15 days to pay their overdue bills before service is suspended. It did not give Sunnyland this 15-day notice. The trial court record indicates a confusing array of possible billing irregularities, but it is not necessary to address them here because CNMEC does not contest the trial court's findings that it was negligent and that it breached its duty to Sunnyland. On the morning of September 9, 2003, before electrical service was restored, several Sunnyland employees engaged in arc welding near flammable materials, including cardboard boxes. In doing so, they started a fire, which ultimately consumed Sunnyland Farms' pack house and operations building. When Sunnyland's employees initially discovered the fire, they attempted to put it out using ordinary hoses. But without electricity, the Sunnyland facility had no running water, and the fires grew. Sunnyland does not contest that its employees were negligent both in starting the fire and in reacting to it, for example, by failing to use a fire extinguisher. Brilliant. Someone living on Sunnyland's property called the fire department. Fire trucks arrived, but they were unable to access well water for firefighting because there was no electricity to power the pumps. Sunnyland had also failed to make alternative arrangements for emergency water in the event that power failed. Firefighters attempted to contact CNMEC to restore electricity to the water sources, but CNMEC employees expressed reservations to the emergency dispatcher, and the firefighters interpreted their statements as a threat that the fire department would have to assume liability. Liability for what was never made clear. The electric bill for one day? Firefighters attempted to use reservoir water to preserve water by using foam and smaller hoses, but the buildings were nonetheless all destroyed. Sunnyland sued CNMEC in contract and tort, among other causes of action, for damages resulting from the fire, alleging that if CNMEC had taken adequate care prior to disconnecting Sunnyland's electrical service, firefighters and Sunnyland employees would have had access to water and the fire could have been contained. The trial court found that CNMEC was liable both in contract and in tort. It calculated the total consequential damages of over $21 million, of which $13.7 million was the net value of the lost crops that the facility would have been able to grow in the absence of the fire. The trial court reduced the damages in tort by 80% to account for Sunnyland's comparative fault. However, in contract, the trial court awarded the entire almost $21.4 million. The trial court allowed plaintiffs to elect a remedy in contract or tort after the resolution of their appeals. Section A, contract damages. Hadley v. Baxendale and Restatement Second of Contracts state the proper test for consequential damages in New Mexico. This court has previously stated that in an action for breach of contract, the breaching party, quote, is justly responsible for all damages flowing naturally from the breach. Camino Real Mobile Home Park Partnership versus Wolf, 1995 New Mexico Supreme Court case. Damages that, quote, arise naturally and necessarily as a result of a breach are general damages, which give the plaintiff whatever value he or she would have obtained for the breach contract. In similar circumstances, the plaintiff can also recover for consequential or special damages, which are not based on the capital or present value of the promised performance, but upon benefits it can produce or losses that may have been caused by its absence. Quoting Ben B. Dobbs, Law of Remedies, Section 12.2, Subsection 3, 1993 book. The classic test for whether a plaintiff may recover consequential damages comes from Hadley v. Baxendale, 1854 English court case. In that case, a mill was temporarily shut down due to a broken crankshaft. The defendants were common carriers who were supposed to ship the broken crankshaft to an engineering company to have a new one built. But the defendants, quote, wholly neglected and refused to do so for the space of 7 days, and the mill was shut down for 5 days longer than should have been necessary. The jury awarded the mill damages for the profits it lost due to the delay. The appellate court reversed, holding that in an action for breach of contract, recovery was permitted for consequential damages only, quote, such as may be reasonably supposed to have been in the contemplation of both parties at the time they made the contract, as the probable result of the breach of the contract. The Hadley standard has been interpreted as an objective foreseeability test. A defendant is liable for losses that were foreseeable at the time of contracting, regardless of whether the defendant actually contemplated or foresaw the losses. From the Restatement of Contracts, Section 351, comment, American Law Institute, 1981. The foreseeability standard is more stringent than the proximate cause in tort law. The loss must have been foreseeable as the probable result of breach, not merely as a possibility. The restatement asks whether there were special circumstances beyond the ordinary course of events that a party in breach had reason to know. Also see UCC Section 2 Tax 715, Subsection 2, little a, which allows buyers consequential damages for, quote, any loss resulting from general or particular requirements and needs of which the seller at the time of contracting had reason to know and which could not reasonably have been prevented by cover or otherwise. In the absence of such circumstances, the breaching party is liable only for general damages. Restatement of Contracts, Section 351, comment B. If a loss results other than in the ordinary course of events, there can be no recovery for it unless it was foreseeable by the party in breach because of special circumstances that he had reason to know when he made the contract. The court has cited Hadley's standard approvingly and described it as the appropriate rule of analysis in New Mexico cases dealing with consequential damages. However, we have also stated that the foreseeability rule anticipates an explicit or tacit agreement by the defendant that he or she will assume particular damages if he or she breaches, from Camino Real, already cited before. We now abandon the tacit agreement test. While we suspect that there may not, in fact, be much space between tacit agreement and the special circumstances required to render a defendant liable for consequential damages, our previous emphasis on the tacit agreement test is confusing and antiquated. We hold that the proper test for consequential damages in New Mexico is the Hadley standard as interpreted in the Restatement 351 of Contracts. In a contract action, a defendant is liable only for those consequential damages that were objectively foreseeable as a probable result of her breach when the contract was made. To the extent the earlier case suggests a different standard, they are overruled. Now, point 2. There were no special circumstances in this case warranting consequential damages. The trial court in this case issued very limited conclusions of law regarding the issue of foreseeability and of consequential damages. The trial court made one finding of fact, stating that the damage suffered by plaintiff were foreseeable and approximate cause, they probably should have said result, not cause, of defendant's breach of contract, negligence and negligence per se. However, in its findings, the trial court did not distinguish between the approximate cause required of tort liability and the more stringent foreseeability requirement of consequential damages in contract. To support the conclusion that Sunnyland's damage were foreseeable to Simrick at the time of contracting, we would expect the trial court to find a special circumstance beyond the ordinary course of events. Despite the voluminous findings of fact by the trial court, there were no findings that special circumstances of this type existed. Sunnyland suggests it was sufficient that Simrick knew that Sunnyland was a for-profit enterprise and depended upon electricity. The trial court found that Simrick employees testified that it was well known within the community that Sunnyland facility was a hydroponic tomato facility. Taking these findings of fact to indicate the presence of special circumstances is problematic for three reasons. First, although the court indulges reasonable inferences in favor of the trial court's judgment, this is simply too speculative. This court does not speculate about what the fact finder might have meant to say but did not say. Secondly, Sunnyland's injury was not directly caused by the lack of electricity. The actual harm was more attenuated. The lack of electricity interrupted Sunnyland's water supply, which in conjunction with Sunnyland's lack of backup firefighting options made it difficult for Sunnyland to respond to the fire its employees negligently started. There were no findings that Senrec should have known that Sunnyland was likely to start fires on its own property or was depending on electricity in order to fight fires that started and that occurred, even if some damage to the tomato crop was foreseeable from the disconnection of electricity. The particular damage that occurred was not, and consequential damages are only permissible if the particular damage that actually occurred was foreseeable. The more circumstances that some loss was foreseeable, or even that some loss of the same general kind was foreseeable, will still not suffice if the loss that actually occurred was not foreseeable. Restatement Contracts, Section 351, Comment A. Third, even if Senrec had reason to know that Sunnyland was dependent on electrical power to power its water in the event of a fire, Senrec would still not be liable without the presence of an additional special circumstance. Hadley provides a good example of what does and does not qualify as a special circumstance. In Hadley, the defendant knew the crankshaft was broken part of a for-profit mill. However, the plaintiff never told the defendant exactly what was at stake, i.e., that there was no backup shaft or alternate plan to keep the mill running. Similarly, in this case, Senrec would have needed to know not only that Sunnyland depended on its electricity for access to water, but there was no backup power source, or that there was a particularized need for uninterrupted water or power. There is no evidence that Senrec had reason to know any of this. In particular, Senrec could not have been expected to know that Sunnyland did not have a separate power source, independent of the power for the main building, for the well that was to be used in the event of a fire. A firefighter's trial testimony agreed that, well, if there's going to be an approved firefighting source of water, it's got to have at least two separate sources of electricity. And one of them cannot come through a building that's being, protected by the pump. And the trial court found that Sunnyland's Farms was negligent in having only one source of power, which ran through the support building to energize the exterior water pump. Senrec cannot have been expected to anticipate Sunnyland's negligence in this regard. In Langley versus Pacific Gas and Electric Company, California Supreme Court decision 1953, provides an instructive example of what a utility company would need to know in order to render it liable for consequential damages in the event of a power shutoff. The plaintiff ran a trout hatchery that required electricity to oxygenate the water and keep the trout alive. If power was shut off, the fish could only survive for 3.5 hours. The plaintiff purchased electricity from the utility and explained the situation to its employees, asking whether the utility had 24-hour monitoring and would always be able to tell him before power was shut off. The plaintiff installed a backup pump that he could activate if he knew the power was cut off. The utility's employees assured the plaintiff that he would be notified anytime the power was shut off. Several years later, power to the fish hatchery was shut off for several hours, and the utility failed to warn or inform the plaintiff. Nearly all of the plaintiff's fish died. The plaintiff sued the utility for breach of contract, and the California Supreme Court upheld the jury verdict in his favor, apparently including the full amount of consequential damages, stating that the measure of the damages was identical under tort and breach of contract theories. The court found that the utility, quote, knew that a continuous supply of electric current to the plaintiff was imperative, and the utility had an obligation to either provide it or to give the plaintiff fair notice. The facts in Langley are starkly different from the facts in the present case. In Langley, the plaintiff had an unusual and pressing need for uninterrupted service, and he took steps to notify the utility company of that need. Unlike in Hadley and the present case, the utility in Langley understood the particular consequences that would result from a breach and accepted the contract anyway. There are no findings in this case that Senrec should have known of a particular vulnerability to fire on Sunnyland's part, or that Sunnyland had no backup source of power or of water. With neither finding nor evidence of any special circumstance, we cannot uphold a judgment for consequential damages. Accordingly, we affirm the Court of Appeals' reversal of the trial court's award of contract damages to Sunnyland. And that's the limits on liability portion of Modern American Remedies, Cases and Materials. Join us next time for Substantive Policy Goals. A more exciting topic could never be seen. Take care, y'all. Have a good night and keep breeding remedies.